Chapter 3 Unlicensed Assistance and License Law Violations Introduction. Objectives. In this chapter, we will discuss issues surrounding unlicensed assistance and look at some case studies involving disciplinary proceedings instituted by the Department of State. At the end of this chapter, you will be able to 1. Name 3 allowed and 3 prohibited activities for unlicensed assistants and list at least 5 licensee activities that violate New York license law. 2. Explain the hearing process and list the penalties for violating the license law. 3. Identify and explain the 4 sections of a hearing decision. Key terms. Remember to pay particular attention to these terms when you see them in this chapter. Administrative discipline. Article 78 Proceeding. Commingling. Misdemeanor. Multiple listing service. Revocation. Suspension. Violation. Click here to complete your New York real estate licensing law reading assignment. Article 12A, Sections 441C, 441D, 441E, 441F. The New York Bureau of Educational Standards requires that you spend 50 minutes studying the material in this chapter. Your course timer can be found in the upper right-hand corner of your screen. Guidelines for unlicensed personal assistants. Many brokers and salespersons today use the services of personal or unlicensed assistants to help with regular, everyday tasks. It's important to realize that, since these assistants are unlicensed, their tasks must be restricted to those activities that are legal for them to perform. So what activities are legal for a personal assistant to perform? Allowed activities. In general, it's safe to say that a personal assistant may perform any office function not described in the license law as one which only licensees may perform. These activities include the following: answer the phone, forward calls, and take messages. Make appointments by telephone for a licensee. Follow up on loan commitments for an already negotiated contract. Get status reports on the loan progress. Pull together documents for closing. Write ads for a broker's approval. Place approved classified advertising. Type contract forms for the broker's approval. Submit approved listings and changes to the multiple listing service. Compute commission checks. Place or remove signs from property. Order repair items for the office. Obtain public documents from county clerks, courts, and water and/or sewer companies. Prepare flyers and promotional information for the broker's approval. Schedule showing appointments for licensees. Gather information for a comparative market analysis. Collect information for an appraisal. Monitor licenses and personnel files. Perform typing, filing and other clerical duties. Guidelines for unlicensed personal assistants. Prohibited activities. New York license law considers the following activities to be appropriate and allowed for licensed personnel only. Hold open houses. Show homes, apartments, or other real property. Discuss specific properties with clients or customers. Assist clients with listings, purchase contracts or other transaction-related information. Negotiate commissions or commission splits. Make phone calls or perform other activities to solicit business for the broker. Perform any other activity that requires a license. Since the broker is responsible for the supervision and control of all activities that take place in the name of his or her brokerage business, the broker is ultimately responsible for any work performed by unlicensed personal assistants, even if such assistants are employed by an associated licensee. Therefore, if a personal assistant performs any licensed activities, both the broker and employing licensee are responsible. Receiving compensation. Personal assistants may be paid directly by either the broker or the employing salesperson. Since a personal assistant is an employee rather than an independent contractor, it would be best to handle compensation on an hourly, per activity, or salaried basis. As an employer, the licensee must withhold federal and state taxes, as well as FICA, unemployment and workers' compensation. If a licensee fails to withhold and pay those items, a claim for back taxes could be made against the licensee or the broker. If an assistant receives compensation on a completed transaction basis, the assistant must be licensed as a real estate salesperson and must receive compensation directly from the licensed broker. In other words, a licensee cannot pay a personal assistant any prorated portion of an earned commission. In addition, a licensee cannot make compensation to the personal assistant contingent upon the successful closing of a property. License law violations. A number of activities constitute violations of New York license law. Here is a list of some of the more common violations. Making a substantial misrepresentation when applying for a license. This could be in the form of a false statement or the omission of an important fact. Committing fraud or engaging in a fraudulent practice, an act which is meant to deceive or misrepresent a circumstance and which results in giving one person an advantage over another. Demonstrating untrustworthiness or incompetence to act as a real estate broker or salesperson. If the broker is a tenant relocator, untrustworthiness or incompetence includes any activities that would disrupt essential building services and interfere with the peace, comfort, and quiet enjoyment of a tenant. Making a substantial or intentional misrepresentation during a real estate transaction, in person or through advertising or other means. Failing to disclose information about any of the following: a licensee's intention to purchase property listed by his or her firm. In such a case, the licensee must inform the seller of his or her intention. The sale or purchase of a property for a client in which the licensee has an ownership interest. In such a case, the licensee must disclose his or her interest to all parties. The person for whom the licensee is acting in a real estate transaction, seller, buyer or both. New York law requires licensees to have prospective clients read and sign specific agency disclosure forms in certain transactions. We discuss agency disclosure in more detail later in the course. License law violations. Other license law violations include the following: acting for or accepting compensation from more than one party in a transaction without the knowledge and written consent of all parties. Accepting as a salesperson a fee or commission for a real estate service from anyone except the salesperson's employing broker. Paying a commission or fee to any person for services performed in violation of the law. Negotiating the sale, exchange or lease of any property with an owner or landlord with the knowledge that the owner or landlord has an existing written exclusive contract with another broker. Offering a property for sale or lease without the owner's permission. Placing a sign of any kind on a property without the owner's permission. Failing to deliver duplicate documents for a real estate transaction to all the appropriate parties. Accepting the services of any salesperson associated with another broker without the knowledge and consent of that salesperson's employing broker. Failing to turn over listing information upon termination of association. Any licensee who terminates his or her association with a broker must turn over all listing information obtained during the association, even if it was originally acquired by the licensee. Being a party to an exclusive listing contract with an automatic continuation clause in NYC. A listing may not be automatically renewed beyond the specified termination date in NYC. A contract must be renewed by signing a renewal agreement in NYC. License law violations. These are also violations of the license law. Failing to provide definitions of exclusive right to sale and exclusive agency listings. This requirement does apply to condominiums and cooperatives as of January 2011. When taking a listing, the broker must provide a written explanation of the difference between the two listings. We'll discuss this in more detail in one of the chapters on agency law. Drawing up legal documents, giving legal opinions or performing title examinations. A licensee may not perform services that should be performed by a lawyer. failing within a reasonable amount of time to account for or remit funds belonging to others that have come into the licensee's possession. Brokers are required to maintain a separate trust or escrow account in a federally insured bank account and deposit money in a timely fashion. Brokers are prohibited from commingling the funds of others with their own funds. Entering into a net listing contract, a contract which allows a broker to keep as a commission any money above the amount the seller specifies he or she needs to obtain from the sale. Failing to maintain agency disclosures and other transaction-related records for the designated 3-year period of time. Discriminating because of race, creed, color, national origin, age, sex, disability, sexual orientation, or familial or marital status in the sale, rental, or advertisement of housing or commercial property. A broker will not be subject to having his or her license revoked or suspended due to a law violation committed by one of his or her associated licensees, unless the broker had actual knowledge of the violation or if the broker keeps the profits or proceeds of a transaction after being notified of the employee's violation. A broker will be guilty of a misdemeanor if he or she employs a salesperson who is not properly licensed. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. Name 4 activities that an unlicensed assistant may perform. 2. Name 3 activities that unlicensed assistants may not perform. 3. List 3 law violations that pertain to compensation. 4. Under what circumstances would a broker lose or have his or her license suspended for a law violation committed by one of the associated licensees? Check your understanding. Answers 1. Name 4 activities that an unlicensed assistant may perform. Get status reports on the loan progress. Pull together documents for closing. Write ads for a broker's approval. Place approved classified advertising. 2. Name 3 activities that unlicensed assistants may not perform. Show homes, apartments or other real property. Discuss specific properties with clients or customers. Hold open houses. 3. List 3 law violations that pertain to compensation. Acting for or accepting compensation from more than one party in a transaction without the knowledge and written consent of all parties. Accepting as a salesperson a fee or commission for a real estate service from anyone except the salesperson's employing broker. Paying a commission or fee to any person for services performed in violation of the law. 4. Under what circumstances would a broker lose or have his or her license suspended for a law violation committed by one of the associated licensees? If the broker had actual knowledge of the violation or if the broker keeps the profits or proceeds of a transaction after being notified of the employee's violation. Hearings and appeals. If the department receives a complaint or has reason to believe that a licensee may be in violation of the law, it will investigate the accusations and notify the licensee in writing of the charge and the penalty. A licensee can request a hearing to contest the charges and penalty. If everyone agrees, the charge may go to voluntary mediation. Otherwise, the department will schedule a hearing. If the department decides to deny a license application, the applicant will be notified in writing. The applicant may then ask for a hearing within 30 days of receiving the denial notice. Applicants and licensees may choose to defend themselves or they can bring an attorney to any hearing. The department has administrative law judges that preside over each hearing. Any action taken by the department can be reviewed. An appeal of a decision can be made to the Secretary of State or it can be made judicially through a proceeding called an Article 78 proceeding. This is actually an appeal to the New York Supreme Court. Penalties for license law violations. If a licensee violates any of the provisions of the license law, the Department of State may take any of these actions. Revoke the license for a period of time that they feel is appropriate. Suspend the license for a period of time that they feel is appropriate. Impose a fine of up to $1,000 payable to the Department of State. Issue a reprimand upon a licensee's conviction of a violation. Note: fines and reprimands are referred to as administrative discipline. Before the department can revoke a license, suspend a license, impose a fine or issue a reprimand, the department must notify the licensee in writing of the charges and give the licensee an opportunity to be heard either in person or through an attorney. The written notice of charges must be delivered to the licensee at least 10 days before a hearing is held. If a licensee has received any commission or other compensation in conjunction with a transaction in which the license law was violated, that licensee could be held liable for up to 4 times the amount of the compensation, in addition to having his or her license suspended or revoked. A violation of license law also constitutes a misdemeanor. A licensee may be tried in criminal court in addition to having a department hearing. New York's Attorney General can prosecute criminal actions. Conviction of a misdemeanor can result in a fine of up to $1,000, a 1-year prison sentence or both. Penalties for license law violations. The Department of State may also choose to suspend the license of any licensee who fails to comply with a summons, subpoena or warrant that relates to a paternity or child support proceeding, is in arrears in the payment of child support or combined child and spousal support. If the department revokes or suspends a license or imposes a fine or reprimand, the department will put the decision in writing and it will be officially signed and filed in the department. Copies of the decision will be delivered either personally or by registered mail to the broker or salesperson and to the person who made the original complaint against the licensee. Once the licensee has received a revocation or suspension notice, the licensee's license and pocket card must be returned to the department within 5 days after receiving the notice. A broker is prohibited from displaying a suspended or revoked license. If the license has been revoked, the licensee is not eligible to be relicensed for 1 year following the revocation. Note: if a broker's license is revoked or suspended, the licenses of all salespersons and associate brokers associated with that broker will also be suspended, until the salesperson can change his or her association to another broker or until the broker's license suspension has expired. Case studies of disciplinary proceedings. Now that we have looked at the types of actions that constitute violations of the license law, let's take a look at some actual cases that were brought against licensees in New York. In each case, the Department of State was the complainant and the person and/or firm against whom the complaint was filed was the respondent. To help you understand the format of the cases you'll be reading on the next screens, here is a brief description. A hearing decision is made up of several sections. Complaint. This section describes what the Department of State thinks the respondent may have done. These allegations are the reason the department started an investigation that led to the hearing. Findings of fact. This section outlines what the court believes happened. Opinion and conclusions of law. This section explains what violations the respondent committed and has references to the specific law that the respondent violated. Determination. This cites the penalty that the court is imposing on the respondent. There are 5 case studies that we will look at, so let's get started. Case Study 1. The respondent in this case is a female real estate salesperson. Complaint. The complaint alleges that the respondent engaged in the practice of real estate brokerage when not licensed. Findings of fact, as follows. Notice of hearing together with a copy of the complaint was served by certified mail addressed to the respondent at both her home and last known business addresses. The notice sent to the business address was returned marked unclaimed. The respondent was licensed as a real estate salesperson from August 1, 2003, to August 1, 2005, when her license expired. She completed a new application on June 30, 2006, and her license was renewed on July 19, 2006, with an expiration date of July 19, 2008. On June 17, 2006, the respondent entered into a brokerage agreement and negotiated a sales agreement for real property located in Rocky Point, New York. The respondent submitted a statement to the department explaining that the late renewal of her license was the result of her being homebound due to rheumatoid arthritis, and that she did not go back to work until she had submitted the renewal application and had been told that she could go back to work. The evidence, however, establishes that she went back to work approximately 2 weeks before the application was submitted. Opinion and conclusions of law. According to Real Property Law, Section 440A, it is unlawful to engage in the business of real estate unless licensed to do so. By entering into a brokerage agreement and negotiating a sales agreement for real property prior to her applying for and receiving her license renewal, the respondent violated that statute. Determination. The department determined the respondent was in violation of the law and ordered her to pay a fine of $500 to the Department of State on or before December 31, 2007. If she failed to pay the fine, her license as a real estate salesperson would be suspended for a period of 2 months after the Department of State received her license certificate and pocket card. Case Study 2. The respondents in this case are a male corporate real estate broker and the company he represents. Complaint. The complaint alleges that the respondents improperly failed to pay earned commissions and compensation for sales promotions due a salesperson associated with them, failed to satisfy 2 judgments, and failed to cooperate with the complainant's investigation. Findings of fact, as follows. Notices of hearing together with copies of the complaint were served on the respondents by certified mail. After a New York civil court trial, a female salesperson who was associated with the respondent real estate brokerage was granted judgments in the amount of $5,195.07 and $3,020, including interest and disbursements. The judgments arose out of her association with the respondent brokerage and her claims that she had not been paid an earned commission of $5,000 and had not received a trip to Paris, which she won in a sales promotion. The broker, who represented his firm in the civil court, was aware of the judgments but did not pay them because he was contemplating the possibility of an appeal and intended to investigate whether the female salesperson, whom he saw only every several months, was making deals and collecting commissions without his knowledge. He had not paid the commission because the salesperson, who had moved to California, had failed to cooperate in the defense of a lawsuit alleging discrimination and had, therefore, caused him to incur higher legal costs in his successful defense than would have otherwise been the case. He had not compensated her for the trip because, he says, the rules of the promotion required the winner to take the actual prize. He believes, but presented no evidence, that she had collected the judgments by executing on his bank account. A licensed investigator left messages for the broker on the firm's answering machine requiring a response. However, he received none. The investigator then wrote to the respondents and requested that the broker appear for an interview on a specified date and bring certain documents regarding the investigation. The broker neither appeared at the appointed time nor replied to the letter. Proceed to the next screen to learn more about this case. Case Study 2. Opinion and conclusions of law, as follows. Since the firm is an artificial entity created by law, it can only act through its officers, agents, and employees, and it is, therefore, bound by the knowledge acquired by and responsible for the acts committed by its representative broker, as well as for the acts of any employees who may have been placed in positions of trust by the broker. Likewise, the broker, as the licensed representative of the firm, is responsible for its actions, and is obligated to supervise the real estate brokerage activities of the salespersons and support staff working at the firm. The Department of State does not have jurisdiction to impose disciplinary sanctions on a real estate broker based solely upon a simple contractual dispute with his or her sales personnel without showing some adverse effect upon the general public. Therefore, the failure of the respondents to pay the salesperson her commission or to compensate her for her success in the sales promotion was not, by itself, grounds for legitimately seeking disciplinary sanctions. However, once the salesperson's claims were reduced to judgments that changed the situation, the failure to pay a judgment which has been lawfully obtained, without showing that he is unable to do so, is a demonstration of untrustworthiness by a real estate broker. The respondent broker admits that he knew of the judgments but chose not to satisfy them. He attempts to justify his conduct by saying that he was contemplating the possibility of an appeal and making an investigation of whether the salesperson had engaged in improper conduct, and with the assertion, and supported by any evidence, that he believes that she obtained payment through execution on his bank account. Once the judgments were issued, the respondents had the obligation to promptly either appeal or satisfy them. They did neither. While the broker's anger at the salesperson's failure to cooperate with his defense of the discrimination lawsuit is understandable, it does not excuse his disregard for the court's mandate. Even if the salesperson did collect her money through execution on the respondent's bank account, it was a demonstration of untrustworthiness to require her to do so. Proceed to the next screen to read more conclusions about and the determination for this case. Case Study 2. Opinion and Conclusions of Law. The Secretary of State has the authority to delegate to employees of the Department of State the power to compel a licensee to supply information. The broker did not comply with the complainant's investigator's written and oral requests for information and documents. He said that he was probably out of the country at the time, since it is his practice to travel with his family in the summer. However, he had no evidence, such as copies of tickets and/or visas, to support this claim. Even if that were true, he testified that he has a substantial business with many people working in it. It is clear that the investigator's letter was received, and there is no evidence that says his telephone messages were not received. As part of his duty to supervise the operation of the firm, the broker has the obligation to leave proper instructions for the conduct of the business, and to stay in contact during his vacations. Even if he was unaware of the 1 written and 3 telephone contacts, he should have left someone in charge to act on behalf of the company. Since he apparently did not make those arrangements, he is liable for the lack of a response. Consequently, the respondents breached their duty to cooperate with the investigation and further demonstrated untrustworthiness. Determination. The department determined that the broker and the firm demonstrated untrustworthiness and imposed a fine of $2,000. If the fine was not paid by a certain date, both the firm's and the broker's licenses would be suspended for a period of 2 months after the department received the license certificate and pocket card. After the fine was paid or at the end of the 2-month suspension, their licenses would continue to be suspended until they could prove that they had paid the previously awarded judgments to the salesperson. Case Study 3. The respondent in this case is a female real estate broker. Complained. The complaint alleges that in regulated real estate transactions, the broker neglected to provide a written disclosure form in 33 rentals of real property, and failed to use the statutory, mandated, disclosure form in 13 transactions involving the sale of real property. Findings of fact, as follows. A department investigator performed a routine inspection of the business practices of this broker's firm and discovered that she failed to use written disclosure forms in 33 rentals and used a disclosure form that lacked an acknowledgement at contract section in 13 sales of real property. The respondent testified that the disclosure form she used in the sale of real property had been approved as to form by a New York multiple listing services company, and she was unaware that a written disclosure form was required by law to be used by a broker functioning as an agent in the rental of real property. Opinion and conclusions of law, as follows. A real estate broker's reliance on information by a multiple listing service is not acceptable as a reasonable excuse or as a defense for the broker's failure to obey a licensing law, rule or regulation. A real estate broker's unawareness or mistake of a provision of licensing law does not excuse the broker's violation of any provision of that law. A real estate broker is presumed to know the law governing the regulated real estate activities in which he or she is engaged. Proof of a voluntary, Intentional breach of a known legal duty is not required to verify a violation of the license law. Therefore, a real estate broker is charged with having knowledge of the law that imposes a duty upon him or her. The state proved by substantial evidence that the respondent violated the provisions of the law when she neglected to provide the written disclosure forms and failed to use the statutory, mandated disclosure form in other real estate transactions. Determination: the department determined that the respondent demonstrated incompetence and imposed a fine of $500. If the fine was not paid by a certain date, all licenses issued to the respondent would be suspended for a period of 3 months. Case Study 4. The respondent in this case is a male real estate broker. Complained: the complaint alleges that the respondent failed to provide a client with a real estate agency disclosure form. Findings of fact, as follows. Notice of the hearing together with a copy of the complaint was served on the respondent by certified mail. The respondent is duly licensed as a real estate broker in his individual name. A potential seller spoke with the respondent about the possibility of selling her house located in Queens Village, New York. At that time, although he agreed to represent her in the sale of her home, the respondent did not present her with an agency relationship disclosure form. Opinion and conclusions of law, as follows. According to the license law, a real estate broker must provide an agency relationship disclosure form to a potential seller at the time of the first substantive contact with the seller. By failing to do so in his dealings with this seller, the respondent violated that statute. The respondent claimed that one of his salespersons subsequently presented an agency relationship disclosure form to the seller. However, the written statement to that effect submitted by the salesperson was not notarized. In addition, the salesperson did not appear as a witness, making it appear that his testimony might not have supported the case. Even if the salesperson's statement was credible, it does not establish that an agency relationship disclosure form was presented at the respondent's first substantive contact with the seller. Determination: the department determined that the respondent violated the law and imposed a fine of $1,000. If he failed to pay the fine, then his broker's license would be suspended for a period of 2 months after the department receives his license certificate and pocket cards. Case Study 5. The respondents in this case are a male real estate salesperson, his employing broker, his employing broker's firm, and a property company. Complained: the complaint alleges that the respondent engaged in real estate sales activity under an unlicensed name other than that of the real estate broker with which he was associated and together with another property company conducted operations as an unlicensed apartment information vendor apartment sharing agent, demanded and collected compensation from persons other than his broker, and together with the property company used an improper form contract and held themselves out to the public as being a licensed real estate broker and brokerage although not so licensed. It further alleges that the employing broker and firm failed to properly supervise the salesperson. Proceed to the next screen to read the findings of this case. Case Study 5. Findings of fact, as follows. Notices of hearing together with copies of the complaints were served on all the respondents at various addresses, including their last known business addresses and the salesperson's residence, by certified and regular mail. The employing broker is duly licensed as a real estate broker both in his own name and as representative of his firm. The salesperson was licensed as a real estate salesperson in association with the employing broker's firm. Neither the salesperson nor the property company was ever licensed as an apartment information vendor. On a certain date, a female prospective tenant paid the property company $150 in return for its promise to provide her with listings of rooms to rent or to refer her to another office which would assist her for no additional fee. The contract she was given was signed by the respondent salesperson as president-CEO. She did not receive any listings, and the other office to which she was referred charged her an additional fee. The prospective tenant returned to the property company's office and unsuccessfully requested a refund. On another date, a male prospective tenant paid the property company $200 in return for its promise to provide him with listings of rooms to rent or to refer him to another office which would assist him for no additional fee. The contract he was given was signed by the respondent salesperson as president CEO. He did not receive any listings, and the other office to which he was referred provided him with 2 addresses at which no one responded. After learning that the salesperson was using the broker firm's listing information for his own purposes, the respondent broker terminated the salesperson's employment and filed a complaint with the Department of State. Since the respondent broker believed that the salesperson had gone to work for another broker whom he assumed had filed a change of association card, the respondent broker did not mail a termination card to the department until 8 months after the termination. Proceed to the next screen to read the opinions and conclusions of this case. Case Study 5. Opinion and Conclusions of Law, as follows. The respondent salesperson's license had expired. But this expiration does not deprive the department of jurisdiction over his conduct which occurred while he was licensed. According to the license law, it is unlawful for any person or business to act or hold him or itself out as a real estate broker without being licensed as such. The complaint alleges that the salesperson and the property company violated that statute by both acting and holding themselves out as a real estate broker. However, what they were doing was operating as an apartment information vendor or sharing agent, a business which requires a separate and distinct license and which, in fact, may not be conducted under a license as a real estate broker. Therefore, those charges are dismissed. According to license law, no person may act or engage in the business of apartment information vendor, which includes the selling of listings of rooms for rent. The salesperson and property company violated that statute and in doing so demonstrated untrustworthiness. According to license law, a real estate salesperson may not receive or demand compensation for assistance in renting real estate from anyone other than the broker with whom he is associated. The salesperson violated that statute by demanding and accepting payment directly from the male and female prospective tenants. The salesperson and property company are charged with violating the law by using an unapproved apartment information contract. However, that regulation applies only to licensed apartment information vendors. Therefore, the charge is dismissed. The respondent broker and his firm are charged with having failed to properly supervise the salesperson. However, the evidence establishes that the salesperson engaged in his unlicensed activity after he had left his employment with the respondent firm. While the respondent broker acted improperly in not immediately filing a termination card, he did file a complaint against the salesperson and, in any case, the failure to file the termination card in a timely manner is not charged in the complaint. Proceed to the next screen to read the determination. Case Study 5. Determination, as follows. The department determined that the respondent salesperson violated the license law and has demonstrated untrustworthiness. For the purpose of determining the start of the statutory 1-year bar to possible relicensure, his license as a real estate salesperson is revoked effective immediately. The complaint against the respondent broker and his firm is dismissed. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What happens if the department decides to deny a license application? 2. What can the department do if a licensee violates a provision of the license law? 3. What happens if a broker's license is revoked or suspended? 4. What are the 4 sections of a hearing decision and what does each section describe? Check your understanding. Answers 1. What happens if the department decides to deny a license application? The department will notify the applicant in writing, and the applicant can ask for a hearing within 30 days of receiving the denial notice. 2. What can the department do if a licensee violates a provision of the license law? Revoke the license. Suspend the license. Impose a fine of up to $1,000. Issue a reprimand. 3. What happens if a broker's license is revoked or suspended? The licenses of all salespersons and associated brokers associated with that broker will be suspended until the salesperson can change his or her association to another broker, or until the broker's license suspension has expired. 4. What are the 4 sections of a hearing decision, and what does each section describe? Complaint describes what the Department of State thinks the respondent may have done. Findings of fact outlines what the court believes happened. Opinion and conclusions of law explains what violations the respondent committed and has references to the specific law that the respondent violated. Determination cites the penalty that the court is imposing on the respondent. Summary review. This concludes Chapter 3. Below is a summary which you can review before taking your quiz. Guidelines for unlicensed personal assistants. A personal assistant may perform any office function not described in the license law as one which only licensees may perform. Activities allowed for licensed personnel only. Hold open houses and show real property. Negotiate commissions. Perform activities to solicit business for the broker or any other activity that requires a license. Personal assistants may be paid directly by the broker or the employing salesperson. Summary review. Summary license law violations. Failing to provide the required disclosures. Accepting compensation from more than one party in a transaction without the knowledge and written consent of all parties. Accepting as a salesperson a fee or commission for a real estate service from anyone except the salesperson's employing broker. Offering a property for sale or lease without the owner's permission. Failing to deliver duplicate documents for a real estate transaction to all the appropriate parties. Performing services that should be performed by a lawyer. Entering into a net listing contract. A broker will not be subject to having the license suspended due to a law violation committed by one of the associated licensees, unless the broker had knowledge or keeps the profits of a transaction after being notified of the employee's violation. A broker will be guilty of a misdemeanor if employs a salesperson who is not properly licensed. Summary review. Summary hearings and appeals. If the department decides to deny a license application, the applicant will be notified in writing and may then ask for a hearing within 30 days. An appeal of a decision can be made to the Secretary of State or judicially through an Article 78 proceeding. Penalties for license law violations. Revoke the license for a period of time that they feel is appropriate. Suspend the license for a period of time that they feel is appropriate. Impose a fine of up to $1,000 payable to the Department of State. Issue a reprimand upon a licensee's conviction of a violation. Fines and reprimands are referred to as administrative discipline. A violation of license law also constitutes a misdemeanor. If a broker's license is suspended, the licenses of all salespersons and associate brokers associated with that broker will also be suspended, until the salesperson can change the association to another broker. Summary review. Summary hearing decision. Complaint describes what the Department of State thinks the respondent may have done. Findings of fact outlines what the court believes happened. Opinion and conclusions of law explains what violations the respondent committed and has references to the specific law that the respondent violated. Determination cites the penalty that the court is imposing on the respondent. Click here if you would like to open this summary as a PDF, which you can then print or save to your device. Chapter 3 Summary. Chapter Conclusion. In this chapter, we have discussed allowed and prohibited activities for unlicensed assistants, activities that violate New York license law, the hearing process, possible penalties for violating the license law, sections of a hearing decision. In the next chapter we'll begin our discussion about the law of agency. Next is your Chapter 3 quiz. Good luck! 1 of 18. Why is entering into a net listing contract a violation of license law for salespersons? Net listings are illegal in New York. 2 of 18 in the case studies, the Department of State is always which party? Complainant. 3 of 18 when must a written notice of charges brought against the licensee for license law violation be delivered to the licensee? At least 10 days before the hearing is held. 4 of 18 in the hearing decision the licensee being charged with a violation is always which party? The respondent. 5 of 18 which of the following statements is true? A real estate broker is presumed to know the law governing the regulated real estate activities in which he or she is engaged. 6 of 18 which section of a hearing decision outlines what the court believes happened? Findings of fact. 7 of 18 the determination section of a hearing decision cites a penalty the court is imposing on the respondent. 8 of 18 which statement is false? When taking a condominium listing, the broker does not have to provide a written explanation of the difference between exclusive right to sale and exclusive agency listings. 9 of 18 an Article 78 proceeding refers to which of the following? An applicant's or licensee's right to appeal a department hearing decision to the New York Supreme Court. 10 of 18 the hearing decision section that cites the penalty that the court is imposing on the respondent is called the determination. 11 of 18 which of the following is an administrative discipline? Reprimand. 12 of 18 which of the following statements is false? If the licensee's license is suspended, he must return the pocket card to his sponsoring broker. 13 of 18 which of the following is not a violation of New York real estate license law? Delivering duplicate documents for a real estate transaction to all parties to the transaction. 14 of 18 if a licensee fails to pay child support, what is the dues authorized to do? Suspend the licensee's license. 15 of 18 under which of the following circumstances would a broker lose or have their license suspended for a law violation committed by an associated licensee? If the broker had actual knowledge of the violation. 16 of 18 if the department denies a license application, the applicant will be notified in writing and may then ask for a hearing within days of receiving the denial notice. 30. 17 of 18 which of these activities could an unlicensed assistant perform? Prepare advertisement. 18 of 18 the section of a hearing decision that describes what the respondent may have done is called what? The complaint.